And I went, 100% for free to there. I graduated first in my class, and while there, I received 18 book awards for having the highest grade in 18 of my 20-something classes. So that's where after law school, I also got a Master of Arts in intercultural studies for fun, because I like to study things. That's all the education that I have done so far, except with the Episcopal Church. I just completed a lay preaching training that lasted for 10 months.
Okay, thank you. Same question for you, Mr. Fox.
Thank you. I graduated from Shelby High School in 1985. I attended Michigan State University until 1990. Took a year off to work in Congress for our National Congressman Guy Vanderjack. Then went to George Washington University in Washington, D.C. for law school. At George Washington, I was on Law Review and published a note in the Law Journal for George Washington National Law Review. I graduated from law school in 1994 and returned home to Shelby, and I've lived in Shelby ever since.
Okay, thank you. And the same question for you, Mr. Good.
Thank you. I have a Bachelor of Arts in Communication with a journalism concentration from the University of Toledo. I spent, I just saw the thumbs up. I spent the first half of my career covering the legal system as a journalist. I'd spent a lot of effort and won a few awards for my work doing that. After a while, it's like, well, if I watched all these attorneys do it, and like, I can do it too. Went back to school, graduated from Thomas M. Cooley Law School with honors, and have been a practicing attorney for the last 11 years.
All right. Our next question sponsor is Bullseye Roofing.
Okay, I will start with you, Mr. Fox. Describe your connections to Oceana County, what brought you here and what keeps you here.
What brought me here are my parents. They're also Shelby High School graduates, and I've had family in this county, in this community, for 6 generations now. And when I graduated law school, we had a choice to come back or not, and it was a happy choice for me to come back. I'm proud of our tradition in this community, my family's reputation, and long-standing connection to the community. And I'm so grateful that we've made the decision to make our lives here.
Thank you. And Mr. Good, the same question to you.
So I refer to Hesperia, where my practice is, as my adopted hometown. The comedic answer I give is I chased my wife up here. My wife traces her family roots all the way back to the 1850s here. One of her family actually has a homestead deed from President Grant in their living room. So am I originally native to Michigan? The answer is no, but I am now.
Okay.
So that's my tie to the area.
Okay, thank you. And the same question for you, Ms. Rupe.
So I'm the newest person here. In 2016, I came on vacation for a week between Christmas and New Year to a little cottage and loved the area. And I bought a house here, what I refer to as my retirement home, about 25 or 30 years too early to retire. But I loved the area. I loved the place. I have traveled around the world. I lived in Singapore in high school. I travel a lot because I enjoy it, and nowhere has as beautiful of beaches as we have on Lake Michigan, and nowhere really has as friendly of people as we have here. So although I am the newest, I did drag my husband and his 2 kids here from California. Just a couple of years ago, we actually had to go to court to get permission to move the kids here. So we are staying here because we can't leave without a court order with the children, but also because we love it. So I'm here to stay. There's nowhere else I'd rather be.
Thank you.
All right, the next live stream and question sponsor is Windridge Textiles.
Okay, I will start out with Mr. Good. What qualities and/or experience do you possess that set you apart from the other 2 candidates?
I will refer to the first half of my career where I wasn't even practicing as an attorney. It was my job to sit through court cases and cover the legal system and explain it to people and to my readers. I got to live these cases, and I got to see the real-world effects of what went on in a courtroom. I got to visit people's homes. I got invited, after one particularly rough trial, I got invited into the family home of a murder victim. During the course of this trial, I'd given them my business card once and said, if you want to talk to me, you can, otherwise I'll leave you alone. After the trial was over, they approached me, and I ended up doing a series that was 2 or 3 parts on the victim and the impact it's had on their family since. I still, every now and then, will hear from mom and dad. It's been a little while now. But I lived that. I was boots on the ground for the first half of my career, so I got to see all of those things and what it meant. And I've carried that kind of forward into my practice. You know, I believe at my core, I'm a public servant in one form or another. I'm still willing to make house calls. I've done it as a practicing attorney every now and then. You know, I've got to visit children in foster homes as part of my practice. So I think what I bring to the table that makes me unique is that I carry a level of real-world experience that I believe to be unique to me.
Okay, thank you. Ms. Rupe, the same question. What qualities set you apart from the other 2 candidates?
So I think there's probably 3 different experiences that I've had in life that set me apart. The first is when I was 13, my family moved overseas to Singapore. That's a very huge time in your identity formation where I was forced to realize that the way that we always did things where I was from is not the way everyone does things. What I thought was normal is not what everyone thinks is normal. And that's essential if you're going to be a good attorney, and especially if you're going to be a judicial officer, because you have to understand that people come to court with different points of view. And they all have a grounding in their reality and in a legitimate reason. And it helps me to understand that my way of thinking isn't the only way of thinking. So that's the first thing. The second thing is in college, I mentioned I did urban ministry with at-risk youth. I was also doing work with mentally ill people. One of the things that I did was people who had mental illness were served by the organization that I was working with. I would go grocery shopping with them. I would go to visit them. I was at their homes and in their places of work and life when they were suffering from a mental health crisis. And this job in particular, the probate court, deals with people, mental health pickups and other things like that, where you have to be aware of the psychological impacts of mental health issues and be able to respond to them appropriately. The third one is that I'm the only candidate with judicial experience. I started my legal career at the Michigan Court of Appeals, where I reviewed entire case files, wrote proposed orders for the appellate judges, and did that in the judicial field. Now I have been working for the last 3 years, almost 3 years, it'll be 3 in September, for Judge Lambrix as the referee in Oceana County. So I am already past my 2-year mark where I have conflicts of interest. I don't have any conflicts of interest with people who come in. I also have learned that the most important thing about being a judicial officer is that you have to listen. Thank you.
Mr. Fox, the same question.
Thank you. The first thing I would say is that I've been in this community for my whole life, but practicing law in this community for going on 30 years. It'll be 30 years this year. And I think that connection with the community provides me with unique insights into what this community needs, what has been harmful and helpful to the community, and that is the first thing I would mention as a unique experience. My second would be, I have been trained in the probate matters. I've received certificates from the Institute of Continuing Legal Education on the handling of probate cases. I believe I've handled more probate estates than any other candidate, probably combined, in the time that I've been practicing law here in Oceana County. I've been handling probate matters since 1994. I've been handling family law matters since 2006. I'll put it this way. I have been through meetings with clients where they've come to me after they've lost a spouse, and we sit there and talk about what happened and how do we move on? What do we do next? And that kind of experience, I think, is crucial. Ms. Rape is right. It teaches you to listen, and to be a good lawyer, you need to be able to listen And to be a good judge, you also need to be able to listen. I think my experience representing people in the most difficult times of their lives gives me a unique opportunity to be a probate court judge. I also would like to mention community service. Service is the lifeblood of a community, and I have been involved in one service organization or another since we moved back in 1994. Just to name a few, and I'm sure I'm not going to name them all, but I'm currently in the Optimist Club. I was the chairman of the Oceana County Community Foundation for several years. I was chairman of the Oceana County Economic Alliance. I was chairman for the United Way Campaign Raising Fund. Those are just the ones I can think of. I know there are more that I've forgotten. Thank you, Phil.
What, I guess in follow-up to that, what prompted you to run for judge, for probate judge?
In my career,
Sorry. In my career as a lawyer, I very much enjoy helping people. And the downside to that is you can only help one person at a time as a practicing attorney. And then at the end of the relationship, you send them a crippling legal bill. And I would like not to do that anymore. I would like to help people without that unfortunate follow-up. And I think I could do that on a broader and more effective level if I were serving from the bench. My idea is to continue to serve the community. I would like to do that from the bench rather than one at a time when they come into my office.
And I would like to ask Ms. Rupe that same follow-up question. What prompted you to run for probate judge?
So I think it goes back to my time in the inner city. I worked with urban youth, and about 10 years later, one of those kids came to my door, and he's suffering from schizophrenia. His mom was dying. He was on disability and getting funds from the government, but he needed someone to manage them, and he was also homeless. And I spent the next decade helping him as his payee. And what I can tell you, he had several touches with the court system at that time, and it mattered who his judge was. It mattered who was deciding what would happen to him. And I believe that I can do what needs to be done to recognize the value of every human person, especially the most vulnerable in our communities.
I would like to give Mr. Good the opportunity to answer that question too. What prompted you to run for probate judge?
Thank you. At various points in my life, when I'm at a crossroads or there's an opportunity, you know, I always ask myself, am I being called to do this? And if we want to talk about spirituality, we certainly can. That's where my motivation came from, is when I discovered that Judge Lambrix was retiring and the opportunity was coming, I genuinely felt called to. Now, called to run, which is a big difference between being called to run and called to be a judge. There's a giant difference. I believe I'm being called to run.
Thank you.
I got to turn myself on. Our next sponsor, the question sponsor, is the Brown Bear.
I will start with you, Ms. Rupe. Describe the duties a probate judge handles.
So in Oceana County, the probate judge has the general duties that go with every probate court, which includes estates, probating estates, guardianships, adoptions, and things like that. Then our probate judge here, because we're a smaller county, also does all the family law things, so divorces, and then post-divorce arguing about children and kids and child support, which is what I do as a referee for Judge Lambrix at this point, as well as juvenile delinquency cases are assigned to Judge Lambrix in our court, and abuse and neglect cases, which are two other areas that I'm currently handling for him as his referee.
Thank you. Mr. Fox, I would like to ask you the same question.
Well, we're going to say the same thing.
Yeah.
She's correct. Those are
Right.
those are the areas of the probate court.
Did you have anything to add, Mr. Good?
Eric and Anna are both correct. That's the breadth of what our probate court handles. I would only add that I think probate court is a lot different than circuit in that probate touches the most vulnerable in a community. All of those cases that that Eric and Anna just described all involve someone who's vulnerable in one way or another.
All right, our next live stream and question sponsor is Oceana Veterinary Clinic.
I will start with you, Mr. Fox. If elected probate judge, what, if any, changes would you make that would positively impact the operations of the court?
That's a difficult question for me to answer because I've worked in probate courts all around our county, from Ottawa to Manistee and to Mecosta, and I believe our probate court is the example that all other courts should live up to. I would attribute most of that to our current judge, Judge Lambrix. Well, check that. I'm sure Judge Lambrix would attribute a large portion of that to his staff. His staff is excellent, and I know that they have helped Judge Lambrix run an excellent court system for the probate court. I see Christy was here today, and she was our probate court clerk and register. She recently moved on to new opportunities, and I also see my former assistant Lucy here. She's taken the job that Christy left, and I know that she will do an excellent job. My loss is the county's great benefit, and I'm really happy for her.
Thank you. The same question for you, Mr. Good. Elected probate judge, what, if any, changes would you make that would positively impact the operations of the court?
So my answer is very little because we have an extremely efficient probate court as it is. The docket management statistics over the last 10 years, I think, put Judge Lambrix's turnout rate at 98%, which means that for every 100 cases that come in, he finishes 98 of them. And there's years where it's over 100%. So that tells me that the court's being run efficiently. The only thing I want to do if elected is I'd like to have a giant stakeholder meeting, preferably at once and preferably with everyone at the same time, to have a big discussion about what probate court's going to look like in the future. The likelihood of me making any changes or any major changes is pretty small. It's truthfully on day one, if elected, it's my job to learn what's going on because everyone in the probate court system in our county is going to know how to do my job probably a little better than me.
The same question for you, Ms. Rapea.
So I think the most important thing to do, as I said, is listen. And I would start by having meetings with every person that works under the probate judge in our court system and the county commissioners and the county administrator, and I would listen to the problems that they're having, the issues that they're having. I see several of these workers in the courthouse today who I care very much about and care very much about their experience in our court and would listen to them so that I had a big picture about what needs to change. That being said, being there already, there are a couple of things that I think we probably should be doing. Number one is sending our employees, probate register and others to other courts, whether it's so that they can learn from those courts or whether we're gonna share information. I know that that's something that the people who work at our court right now would appreciate the opportunity to do. Another concern that I have is that there's actually a statute that requires guardianships to be reviewed every 3 years and after they were established 1 year, and I don't believe that that has been done recently. And that's concerning to me because when we talk about the most vulnerable people, the court is here as the backstop to terrible things happening to people. That's what our job is. And I think that we need to continue to do that, what's required under the law. So those are a couple of things that I'm aware of. I would listen first before I made any major changes, to be sure.
Okay, thank you.
Additional. All right. The live stream and the next question is sponsored by Heron Construction.
Okay, I will start with Mr. Good. What role does the Constitution play in the decisions you would make from the bench?
Well, it's the backbone. I mean, everything we do in court starts with the Constitution. I mean, I enjoyed constitutional law in school, but if I go on too long, I think some people's eyes are probably going to start rolling around in their head. I mean, that's where you start. I mean, the constitutional rule is where everything starts and where every statute is based, and then it trickles down from there. So any decision that's made, has to have the Constitution and constitutional rules in mind.
Thank you. The same question for you, Ms. Rapea.
It is the backbone of our community. I would say that the Constitution is primarily concerned with restraining governmental interference in people's lives. And so there are many rules and laws, even that are coming out right now, that people are concerned about how those are affecting our rights, our Second Amendment rights to have guns, our 14th Amendment rights to control our own bodies. The question is, when can the government interfere? What constitutional law tells us is the balancing test that the court is supposed to use to determine that. And the more intrusive the governmental interference, the heavier or bigger the test is. So you have to be aware of the Constitution, you have to be aware of those tests, and then you have to use the test to make the determination. Judges are given so much discretion about things that we have to use the tools that we're given and the guidance that we're given from the legislature and our controlling documents like the Constitution so that we know what to do. And there are many times when I'm sitting in the room going, which parent should have custody? And I'm like, okay, I've got to go through the steps, and they give me the steps to go through. This is not the Constitution, but it's a statute. They give me the steps, I go through the steps, and I'm like, okay, it's very clear.
Okay, thank you. Mr. Fox, the same question?
I don't disagree with what Ryan or Anna said, but I think I'd answer it a slightly different way. In my 30 years of practicing law, I have had maybe 2 opportunities to make a serious constitutional argument before a court. It is not as common as the general public might think it is to have a constitutional debate or a constitutional argument that you want to make to a judge. So, yes, the Constitution is our founding document. It's very important. I respect it. I cherish it, frankly. But it really has very little to do with the day-to-day operations of our court system. The legislature passes statutes which we have to follow. Anna was speaking of one of those when it comes to best interest factors for the child. That comes into effect every single day. Mm-hmm. And we have to follow the statute. As judges, we would be required to weigh the factors and consider each of them and make a decision based on those things. That's a much more practical and applicable statute to consider than the Constitution is daily.
Okay, thank you.
All right, the live stream and next question sponsors Harbor Design.
I will start, I kind of forgot where I was trying to give everyone an equal opportunity to start first. I think I'm on okay, so I think it's Eric, or Mr. Fox. What in your private practice experience most qualifies you to perform the work of a probate judge? Specifically, have you appeared in probate court handling estate cases representing dementia patients, abused children, etc.?
Yes. When you're talking about estates, I guess technically a disabled person has an estate. But when I consider estates, I'm talking about probate of deceased persons' estates. Mm-hmm. And I've handled so many of those. With the assistance of Lucy up until recently. But I've in the several areas I mentioned at the beginning of this discourse, I've practiced probate law in all of our surrounding counties, and I've handled more estates than anybody else, I'm highly confident. There are estates for disabled individuals, and they need guardians, so there would be an estate proceeding for appointment of a guardian. There would be an estate proceeding for appointment of conservators. And I've been in all sorts of cases where both the conservator and guardian are uncontested and to go smoothly, or we could have a 4-day trial like I did in Mason County earlier this year, where there was a contest about who would be the conservator and guardian for an elderly woman who had dementia and needed assistance. So I have extensive experience in all of those probate matters that you referred to.
Okay, thank you. That is the same question for you, Ms. Rupe.
I would say yes, that I have handled many of those types of cases as well. It was not my primary area of practice, but I did handle some sometimes, and I've handled a lot more now as a referee. Mm-hmm. Although I have not handled the guardianships, adoptions, etc. as a referee.
Okay, and the same question for you, Mr. Good. I don't know if you want me to repeat it.
It's
kind of
fine.
long. Okay.
I think I remember it.
All right.
So when people ask me what kind of law I practice, I tongue-in-cheek say hometown law. And part of that is handling people's estates. I think at this point, I probably have 15 probate estates open either in Oceana County or in the surrounding counties. I've done guardianship and conservatorship work, and some of that work has included what's called attorney guardian ad litem. I've had judges appoint me to represent an adult who's about to get a guardianship or conservatorship imposed on them, whether they want it or not. And this is part of what I've carried over is, that requires visits to these folks' homes. It requires me having longer conversations in their homes on why this is happening and then advocate for them in court. I've done the same thing for abused children. I, from time to time, get appointed as lawyer guardian ad litem for an abused child who's been removed from their home by CPS. Then it's my job to visit that child at least once every reporting period, and it's 3 months or 6 months, depending on the length of the case. And meet them either in their placement or their foster home and check up on them and see how they're doing, and then advocate for them in court. I've found that to be really rewarding and incredibly frustrating, and that can all happen at the same time in the same case. So anything that a probate court judge in our county handles, I've done. Divorces are a big part of my practice too, and divorces with children are also a big part of my practice.
Okay, thank you.
The live stream, the next question sponsor is Halleck Contracting.
I will start with Ms. Rupe. When I talked to Judge Lambrix during his outgoing interview, he said it's been a real challenge in recent years as to the level of conflict in which people engage. Instead of resolving matters, they want to litigate. What experience do you have in mediation, and how would you attempt to resolve these types of conflicts as probate judge?
Okay, so in law school, I did take a mediation class and did quite a bit of mediation activity during that class. I also took a later mediation training during my practice time. I think that the type of law that I practiced put me in relationship as their attorney with people who are very difficult to deal with. So if you can imagine it happening, it probably has with my clients and what they say. And my job was to get everyone to agree. That is the job of an attorney if you can resolve things. So I have experience in that. I think that's part and parcel of being an attorney and being a good attorney is you have to get people to some place where things are resolved. The reality is, as a referee, I look at people all the time and say, it would be better if you would decide, because you know your kids better than I do. But I am here and I am willing to make that decision for you. If you can't, just know that I'm limited in information to what you are legally allowed to present to me. So please go have mediation. And anytime there's a hint that mediation would happen, I would refer them to mediation. And that happens outside of the courtroom. I think sometimes people want judges to tell them what the decision's going to be, which we're ethically not allowed to do. So it's either mediation or I'll decide for you, and you can choose.
The same question for you, Mr. Fox.
Thank you. Actually, I act as a mediator for attorneys looking for an out-of-court resolution. In fact, I mediated a case this morning to a successful settlement, and I think everybody left the room, if not happy, at least very satisfied that they don't have to go to court. And I have been mediating since 2006, 2005, when I was trained by what was called then the West Shore Dispute Resolution Center. Now it's called Mediation and Restorative Services. And I was trained in a 40-hour course to conduct mediations, and I've been doing it both as a volunteer for the center and as a paid mediator for attorneys looking to have an out-of-court resolution. Since that time, Ms. Rape is right. It is a better solution to come to one that you agree upon than to have one imposed on you. In fact, that's one of the reality checks that mediators use to encourage people in mediation to continue talking about how they might resolve it. Mediation also taught me how to diffuse high conflict situations. Oftentimes, just sitting still and being silent while your client in that session gets it off their chest is an important part of the process. And it's a skill that you have to develop, and it's one that I've developed. Even when I'm dealing with clients outside of mediation, it's important to be able to diffuse angry situations because, as I mentioned earlier, you're dealing with people at the worst times of their lives in some cases, and there's going to be some anger, and you need to be able to handle that. And I can handle that, and I think a judge needs to be able to that, and I think I do that job well.
Okay, thank you. Mr. Good, same question?
So I would certainly agree with the notion that it seems like the level of conflict people are willing to engage in has gone up over the years, and that's a longer discussion than we can have tonight. I tell every divorce client who comes to me that when we're finished, you will not be entirely happy with the outcome. There's no such thing as a winner in a divorce case. I'm fond of mediation. I've done it several times. I'm also fond of something I've done somewhat on my own, but just to simply invite opposing counsel and the opposing party, either their office or mine, I don't care, and we're just going to sit down and talk about it together. Now, I've been through enough mediations now, officially, formally, with a mediator that I've seen pretty much, not necessarily the script, but how these go. It's like, you go first, what do you want? You go second, what do you want? And then never raise your voice. I've done several divorces that way where we've mediated it, but I wouldn't call it formal mediation. I mean, it was simply everyone getting together and talking. You know, then when it's over, if we really think we need to go back to court and have a judge decide instead of you guys figure it out, you know, we can do that. But anytime you get to a mediated agreement, in any matter, divorce or otherwise, whether it's through a formal mediator or whether it's done informally, the way I've tended to do it, people tend not to go back on those orders and file post-judgment motions and say, well, I'm not happy with this, if they came to it themselves. So that's the ultimate goal.
Okay, thank you.
The live stream and next question sponsored is Country Dairy.
I think I'm starting with you, even though I just ended with you. The next question is, at what age is a person considered a juvenile, and how does juvenile law differ from criminal law?
So juvenile law differs in that there is more of a focus on the child. A child gets charged with a crime in a juvenile delinquency case. There is much more of a focus on how do we fix this kid so he or she doesn't do this again. That can mean restorative services. That should mean some form of counseling. The movement lately has also been, if you have a kid in a juvenile delinquency case, that the entire family ends up ordered to go handle those things. Any matter in juvenile court that involves a juvenile should be handled differently, because we're talking about someone who's not fully capable of making their own decisions and may have made a couple of really bad ones for circumstances maybe in their control or maybe out of it. I've practiced in juvenile law quite a bit. I've represented several juvenile delinquency clients. I hate the term delinquency, but that's the term the statute affords us. And, you know, my concern is always what brought us here. You know, and there's always a deeper story in a juvenile delinquency case than just the kid committing a crime. Some of the confusion, too, that goes along with delinquency specifically is when a juvenile is charged with a crime, he or she is charged with the adult version of the crime. So they'll come to me the first time and they may be charged with a 4-year felony, and the kid's eyes are just this big because it's like, I'm going to go to, you know, I'm going to go to prison for 4 years, and it's like, no, these are handled differently. And it's kind of working through that process with them.
Okay, thank you. Ms. Rupak, could you answer that question?
Sure. So a couple of years ago, the legislature changed the age for juvenile crime from 18 to 17. So when I first started practicing, if you were 17 and committed a crime, you were charged as an adult. Now you're not allowed to do that. That's had some unintended consequences as far as access to detention beds. Our 17-year-olds commit more serious crimes typically, and so they're taking up all the detention beds. So we have kids that are very recalcitrant and unwilling to follow the court's orders that we don't have places to put them anymore in detention. So one of the things that, as I've been campaigning, I've been talking about is how we as a community need to decide how we're going to handle that, because we have a lot more juveniles in our community that need a lot of support. The legislature is also changing the focus, swinging on the pendulum toward community-based interventions with juveniles. So that has changed. That's always been on the table for juveniles, but now the legislature is telling us we have to have cooperation with local community organizations. And for small rural counties like Oceana, that is a challenge, because we don't have the 400 nonprofits running that they have in Grand Rapids, where they already have 25 million programs that they can send kids to. We don't have that. So we're gonna have to think about how and when we'd like to create that. The other thing I would say is different is the range of options I have and the length of time that I have to do those options for a juvenile. If someone is charged as a juvenile, I can put them on probation, I can warn them and dismiss the case, but I can also send them to detention or to foster care and keep them there until 19. And if it's a super serious crime, up until age 21. So I have a wide range. In every case, those are always my options.
Your 2 minutes are up. Ms. Rupp.
Thank you.
Mr. Fox, same question.
The issue of juvenile delinquency is the thing I heard most when I was meeting with our community organizations. And I think the issue boils down to we don't have the resources in this community to handle the needs that our juveniles are showing or are demonstrating to us. I think it would be, I know judges have a reluctance to get out in the community and advocate because they don't want to endanger their appearance of impartiality. But I also think it's important for a judge to make the issues like this known to more than just the service organizations or law enforcement or the court staff who deal with them every day. And if I were elected, I would, as judge, go to service organizations, the community foundation, and let them know of the need. I don't think it's as well known in the general population as it is among the courthouse staff and law enforcement. So I think it's important that that be handled that way. Thank you.
Thank you.
Our final live streaming question sponsor is Myers Chevrolet.
This question is quite similar to what I had asked, but you might be able to elaborate a little bit more. I'll start with you, Ms. Rapay. Juvenile offenders are often released to the custody of their parents after being apprehended by police. What are examples of crimes committed by juveniles that require them to be lodged in a detention center?
So that's an interesting question because, again, the changes to our laws in the last couple of years have restricted where we can put juveniles. So when we arrest them, they cannot be placed in the adult jail. They have to be placed in a place where they can see no adult offenders or hear no adult offenders. So serious crimes like sex offenses, murders, serious assaults, some of those you have the ability to detain people, but like everything else, there is a list of things that I'm supposed to do. If I'm gonna do pretrial detention, which is detention before a kid has been adjudicated guilty of something, I have to go through a host of factors, which I have to determine that it's a danger to themselves or the community to be released to their parents. Mm-hmm. And that's a proactive finding, meaning I have to go and I have to say it's going to harm them or the community, so I need to put them away.
Okay, thank you. The same question for you, Mr. Good.
So placement out of the home as a general notion in juvenile delinquencies is going away. We can say that we need to place a kid out of the home, but there are no facilities that are willing to take them. The closest one to us, I believe, is Ottawa County, and they have severely cut how many beds they offer, and they, for a time, were only taking kids from Ottawa County. I heard one horror story. I don't recall the county. I think it was St. Joseph, but I could be wrong. A child was accused of stabbing his grandmother with a shank, and he ended up placed with a relative that night because there was no place to put him. Now,
Wow.
if placement out of the home in the pretrial stage of a case has to happen, it has to happen, but we all need to understand that finding a space for him is going to be extremely difficult. The funding for these places from the state level has dried up, and the willingness for people to open them on their own is not there anymore.
Okay, thank you. Mr. Fox, same question?
That's all true. Again, it goes to the lack of funding for these type of facilities. When I was speaking with our police, our village and city police officers, they were bemoaning the fact that because the closest place they could find a placement for a juvenile delinquent was in Indiana, they had to get into their car, drive that child to Indiana, and then return, taking them off their beat for that entire period of time, racking up an overtime bill. We're going to spend the money. If children need to be protected from themselves or to protect the community from dangerous children, we're going to spend the money. I would hope that we are able to raise the money and help them make a more cost-effective placement for these children. I was working with I was appointed guardian ad litem for a child accused of a crime, and he's caught in limbo right now because of this exact situation. He doesn't have a place to go. He's stuck in his facility, even though he's completed everything that we've asked him to do. But there is just no place for him because our social services system is not up to the task at this point.
Okay, thank you.
We have no more sponsors, so you can just keep on going.
Okay, thank you. This question is it's kind of redundant because of the answers I received from the first one, but I will start with Mr. Good. Local law enforcement has expressed difficulties with the lack of available detention centers. Where is the nearest juvenile detention center, and what do you propose to handle the lack of juvenile facilities? How would it be funded?
As far as I know, the closest juvenile detention facility is Ottawa County, and that's not terribly close to us. Muskegon River Youth Home, although it's not called that anymore, and the new name slips me, at one time was a 60-bed facility. They just reopened it, and it's 8 beds. I've, in campaigning myself, I think Eric and I have probably had the same conversations with law enforcement about the frustration in not being able to place a kid who needs to be placed. I can't sit here and say that I would do this as a judge or I would rule this way as a judge, but this is definitely a solution that we're going to have to figure out.
Same question for you, Ms. Rupe.
So I am aware that we do have a contract with Muskegon County to take for one detention bed. So that's good. It's not enough, and we don't want to send kids away, but sometimes they're not safe where they are, and the community is not safe when they are there. We do have something called the Child Care Fund that does reimburse things, but they're changing, again, the designations of where they want us to be spending those Child Care Fund dollars. Some of the things that we do to keep kids out of detention are now being far more heavily funded by the state of Michigan through the Child Care Fund. So they are trying to motivate us, as the government often does, with money to do things the way they want it done, which is to keep kids in their homes longer. This is why I have been talking about this in so many communities where I have been this year, because we need to decide as a community what we're going to do with these kids. We have a very special place where neighbors look out for each other. You probably can tell me on your street where the troubled families are. What if we together decided that we were going to do something about that before we get to the point where the juveniles are committing crimes and their families are falling apart? This is where communities of faith and community organizations can and need to really step into the gap, because the state of Michigan doesn't want to fund it. Do we really want to spend that much money to send a kid away? It's not going to solve their problem. They're going to get out and they're going to come back. So we need bigger answers. We need people-oriented answers, and we actually have the people in this community to answer that question, but we do need to have conversations about that to figure out what we're going to do. I could facilitate that as a judge. I would, out of the gate, put that as a very high priority for myself, to facilitate those conversations. But that is not a problem that one person, even if it's the probate judge, can solve.
Mr. Fox?
I don't really have very much to add on. It echoes what we've already been talking about. I mean, we're talking about getting funding from other sources than the government because the state of Michigan has inadequately provided that, and I agree completely.
Okay, thank you. I'll start with you, Ms. Rappe. Please explain the juvenile justice reform package slated to take effect, what that entails. It's supposed to take effect October 1st?
In October?
Yes.
Okay, so there's several changes. The highlights are some of the things that I've already been talking about. So one of the things that has a practical effect is that we're not going to be able to charge juveniles money anymore. So when somebody had a vaping ticket, because vaping was rampant in basically all of our schools, the answer that the court had was pay $50, it'll motivate your parents to get on your tail about vaping, maybe we'll stop you from vaping. That was what we were doing. We can't do that after October 1st. So what are we going to do? We're gonna have them come in and watch a video about how vaping is harming them. And then what are we gonna do when they keep doing it? Like, so this is again where the legislature making decisions is actually tying our hands for what we can do with these juveniles. And I'm not sure that we're gonna result in what they're hoping for, which is something other than charging families money. That's not the end all or be all either, but that's one very practical thing that we're talking about. The other thing is the child care fund and the reimbursement. So they've changed how they're reimbursing things, and they're pushing the probation departments toward community-based activities, solutions, programs, so that you're gonna get higher funding dollars when you're doing those things that aren't detention. So that's one of the major things that is happening. So those are probably the two that I would say that I see right now have the most practical effect on how we're doing business with juvenile delinquents in Oceana County right now.
Okay, thank you. Same question for you, Mr. Good.
So Ann is right, so I'm not going to repeat anything she said. Basically, on a broader level, the focus has been more toward, and again, like Anna said, more toward rehabilitative services and making sure that this particular offender, this kid, doesn't do this again. Fines and costs for kids are going to go away here before too long. And, you know, the arguments for and against that, we've all heard them. So, you know, I can repeat them if everybody really wants to hear it, but there's now a focus on community-based intervention much more so than punitive intervention.
Okay. Mr. Fox?
Briefly, if we refocus the limited dollars that the state of Michigan or the departments dole out for juvenile delinquent cases to community services, that will decrease the amount of funds that we have available for beds, and there's already a shortage of beds, so that'll make the shortage even worse. And we are going to have the problem that we've all heard about and talked about a little bit tonight, exacerbated. So the reaching out to alternative funds and alternative sources of funding is going to be even more important after these changes take effect soon.
Okay, thank you. I will start with you, Mr. Good. In addition to probate court duties, the judge is cross-assigned to handle criminal matters in circuit court if the circuit court judge is unavailable. What experience do you have in criminal court cases?
So, since I've been practicing, I've handled criminal matters on a retainer basis. Since 2020, I am on the Michigan Indigent Defense Commission roster. I take court-appointed criminal defense cases in Oceana County. That generally leads me to probably 2 jury trials a year on a criminal matter of one kind or another.
Okay, thank you. The same question for you, Ms. Rappe.
So I did quite a lot of criminal defense when I was in private practice, but I did only court-appointed work. I will say I took maybe 3 cases that people paid me to handle. And I did that because I very strongly believed that people who are indigent deserve the same kind of criminal representation as people who can pay for an attorney. And so I always joked with my social worker friends that I was a higher paid social worker because that's what I did. When I was doing criminal defense. I did criminal defense mostly in Kent County, a little bit in Oceana County right before I worked as a referee. I also was on the CJA panel, which is the court-appointed panel for federal cases in the Western District of Michigan and for the Sixth Circuit. So I did trials in federal court that were multiple defendants, week-long trials with, I think one time I read like 30,000 pages of telephone calls and or texts, which were very interesting, of drug dealers. They all lost, by the way. They all lost in federal court, so don't think that I got them off because I didn't. But I did the work and I worked really hard. So I did that in federal court. I also did briefs and oral arguments in the Michigan Court of Appeals and the Sixth Circuit Federal Court of Appeals. And I have written briefs for both the Michigan Supreme Court and and the U.S. Supreme Court. So I've sent briefs and practiced in all of those places on the criminal side.
Okay, thank you. Mr. Fox, the same question.
I do not take any criminal appointed cases. I have represented many people in criminal cases, but I'm not a court-appointed attorney. I would admit that my experience in criminal law is probably less than Ryan and Anna's. It's definitely less than Ryan and Anna's experience in criminal law. Fortunately, our probate court is required to do less of that cross-assignment work now. I think a lot of that happened because of a conflict of interest that had to be addressed, and I don't believe Judge Lambrix has very many opportunities to practice criminal law any further, so.
Okay, thank you. I'll start with you, Mr. Fox. Your job is not to write the laws, but can you give us an example of a law that you believe should be changed and why?
I can think of laws that I've seen in other jurisdictions that I think Michigan should consider. One of those is called an improvident transfer statute, a uniform improvident transfer law. And it deals with situations where a person is near the end of their life or suffering from some debilitating mental or physical illness that prevents them from acting coherently or in their own best interests. And they can be susceptible to undue influence or abuse by their family or even friends and give away things that they need. And Vermont, for example, has this improvident transfer statute. So it's presumed that undue influence has occurred if certain criteria are established. We don't have that in Michigan. You have to go to great lengths to prove an undue influence case now, which is something the probate court would handle if that were ever the case. But I think that would be an excellent idea for our legislature to think to adopt.
Okay, thank you. Same question for you, Mr. Good.
So if we're asking about pet peeves, I
Pretty
could
much.
probably go on for quite a while. The one that comes to mind first is in criminal law. There is a hybrid form of charge called a high court misdemeanor. The maximum penalty for a high court misdemeanor is 2 years, and it causes a ton of confusion because the client will inevitably think that they're being charged with a misdemeanor. However, they're not. In a high court misdemeanor, for sentencing purposes, it's treated as a felony. There's a pre-sentence report, there's a sentencing guideline score, yet we don't call it a felony. I would prefer it if they would just refer to it as a 2-year felony and save everyone the confusion.
Yeah, I've experienced that with writing about those kinds of cases. Same question for you, Ms. Rupe.
So when I was in law school, professors always said, like, bad facts made bad laws. So I would group in there any law that's been passed because something really terrible, tragedy happened and somebody died, and we decided we needed to make a law to protect people from that. Most of the time, our general rules apply in pretty much every situation. But when somebody dies and the family gets upset and they go to the legislature, we have like millions of things that are on the books that we're prohibited from doing when just the more general prohibition would have done. So I can't be more specific than that because it's actually kind of a lot of rules that we have in life that are just so specific. And the reality is that tragedies don't create good law because it's a tragedy. And as much as we want to control life in situations by making lots of rules for everyone to follow, we can't.
Thank you. Mr. Good, who is a mentor of yours and why?
This may win me votes or it may lose me votes. My first job after I was licensed was with John Greer in Fremont. I still refer to him as a mentor, and he gets a giant kick out of that every time I bring it up to him. I learned more about the practice of law in the year I spent with him than I did in 3 years of law school. John is a dear friend of mine. We still have cases together every now and then, and he will point out to me every time we have a case together, he goes, you know, you consider me a mentor. And it's like, yes, John, I absolutely do. I'm very fond of him, though. John is a dear friend of mine.
Oh, good. Same question for you, Ms. Rupe.
So I have been blessed to have many, many, many mentors. Most of them have been professors of mine. But when I worked in Kent County, basically every attorney who had been around longer than me was willing to take a phone call. And law school doesn't actually prepare you for the business of doing law. We talk about abstract stuff in law school, and then you go and you're like, how the heck do I file this document? There were so many people. Mike Dunn is one. He was an attorney in Michigan and in Grand Rapids, and I took his place on the CJA panel. So I called him repeatedly for help. I think that was one of the best things about working in Kent County was that there were so many attorneys that were willing to mentor me.
Okay, thanks. Same question for you,
I
Mr.
have
Fox.
I have a similar answer. Law school, she's right, law school does not teach you how to practice law. And I had the benefit of many attorneys. When I first started working in Muskegon with League Newman and Irish, there were 20 attorneys in that firm, and they were all helpful to me, but no one was as helpful to me learning to practice law as my first legal secretary. She taught me more about how to get something filed, or, oh no, that's not the way to do this, Eric, you better check that again. Diane Hubbard is her name. I don't know if she's still around, but she was so impactful to the beginning of my legal career.
Thank you. This is actually the last question. I will start with you, Ms. Rupe. Tell us about your value system and how that will impact the decisions you make from the bench.
Okay. So my dad was a pastor, and then my family were missionaries, and we moved overseas when I was 13. And my faith is the center of my life. I make decisions because I think they're the right decisions, and much of that it's informed by my faith and my faith history. I really can't talk about my life without talking about how God has impacted my life. I think as a judge or as a judicial officer, as I am right now, my faith requires that I treat every person with the same value and respect. I value the human story. I value what is happening to you because I see that you are valuable. It makes me want to listen to your story. It makes me want to understand who you are and what brings you here. And also, my faith is about reconciliation and about bringing people together and solving all of the problems in the world that come from our selfishness and our horribleness and the bad decisions that we make. And so my faith gives me the motivation to help people figure out how to get along and to prioritize the people in their life over things, over ideas. It's the people who are important. So that's the center of my value system. I'm going to make the choice that I believe is just, is fair, and is right for all of the people that are appearing in front of me. And I do the best that I can, and sometimes I get it wrong, but I do the best that I can because I'm human too.
Okay, thank you. Mr. Good.
So the three things, and John actually taught me this: patience, perseverance, and kindness. I was born in, grew up in, and continue to practice in the Roman Catholic faith. And that centers around everything I do. If you ask me what my top 3 jobs are, lawyer isn't one of them. It's follower, husband, and father. Those are the most important things to me. I think my faith makes me good at my job because it's very clear when we're taught how to handle situations like ours. And like Anna said, how to handle conflict, how to be patient with people. And people don't often realize it, but kindness and weakness are 2 very different things. You can be kind to someone and not have to put up with it. It's that system that I've carried with me my entire life, and I think that system would carry forward well as a member of the bench.
Okay, thank you. And Mr. Fox?
You asked about source of values.
Your
Is that-
value system, I can repeat the question.
That's
Tell,
okay.
tell us about your value system and how that will impact the decisions you make from the bench.
Well, my value system comes from my parents and my family. I was raised in an agricultural family. I grew up working in the farming operation, starting packing apples. I think I was packing apples at 12 years old. Don't report that. That might be. I guess farmers get an exemption for child labor laws, so we're good. But I learned hard work from my family. I learned honesty from my family. I learned frugality from my family. And I learned that family is the source of most of our happiness. And I'm so glad that most of my family, my parents, my grandparents when they were alive, my great-grandparents, I was so fortunate to have them all here in Oceana County and to be raised in that environment. I know that's where my value system comes from.
Thank you.
So I actually have one more question for my 17-year-old son. So you can all answer it during your closing, 1-minute closing, or just before that. We'll give you, that would kind of go together, the closing comment and the question. His question to me was, this was a true question, what's the most creative use of a gavel? And then you can give your closing statement. So we'll start with you, Mr. Fox.
I have not had the benefit of owning a gavel yet. That's why I'm here. A closing statement on top of that? All right. As I've hinted at throughout the conversation tonight, my 30 years of practicing law in Oceana County have given me so many opportunities to meet with people in times of happiness and in times of sadness, and to help them through their difficulties, and I'm the richer person for it. I think that experience has given me the insight to know what litigants need or parties need when they come before the court, and I hope that you will consider voting for me August 6th. Thank you.
Okay, so the gavel question threw me off. I spent all my time thinking about that instead of my closing statement. But I will say, chitty chitty bang bang, that inventor guy, he would have made breakfast with the gavel. And to me, I think that would have been the most creative thing. As far as my closing statement, what I want you to know is I'm here because I care. As I said, people are valuable to me. I am here because I want to listen to you. I think the most valuable thing that I can do is listen. I'm also a student. I'm a nerdy student. You heard how many degrees I have for no reason because I like to study things. I think that's a good thing for a judge to do, is to study. I think being a student of the law is very important. I don't need this job. I love the job I have. Actually, I probably have more time with litigants right now than I would as a judge, because as a judge, I would do a lot more administration. But I think I can do a good job. I love the people that I work with. I love the people that I serve. I care about how things come out. I will never not care about what's in front of me. And so you can if you're going to entrust anyone with the discretion to make decision about the people that you love, I hope that you choose it's someone who cares about them too and cares about what's best for them. So I hope you'll consider voting for me August 6th.
Good?
So I suppose with a little bit of alteration, you could probably use them in the axe throwing bars that are now quite popular. I don't know, you probably have to sharpen the edges down a little bit or else it would bounce off. That's as good as I can answer that one. I've already talked about my qualifications and my unique set of experiences and how much time I've spent in the real world outside of courtrooms and what courtroom rulings mean to people in their living rooms because I've sat in those living rooms. I know what it's like. I have a very unique understanding of what the legal system means for people once, the attorneys and the judge go home. My philosophy moving forward, and I talked about this too, I believe this to be another step in public service. I believe a judge, any judge, to be probably the highest form of public service. I can promise everyone right now, if elected, you will never hear me say, my courtroom, my staff, my this, my that. The courtroom does not belong to the judge who sits in it. The courtroom belongs to the people of the county. It's the judge's job to be a good steward of that system. It's to make sure that the people are well served. That's my philosophy moving forward, and I would politely and respectfully ask for your vote on August 6th.
All right. Well, can we give the candidates a very nice round of applause? Thank you. And also, I'd like to thank Scott Myers and Courtney and Allison for the wonderful job that they did behind the scenes. Yep. All right, and also, if you want to rewatch this, you know somebody that couldn't make it tonight, this actually is live streaming right now, but it's also being recorded on the same exact QR code on that flyer, so you can access it through that. Also, if you don't know how to use a QR code or do all that, go to YouTube and then go to CatchMark Community, like in the search bar on YouTube, CatchMark Community, and just type in Oceana County, all one word, all one phrase. So CatchMark Community, Oceana County, and this video will pop up on YouTube. All right, thank you so much for coming, and have a great night.